land reforms in a way is called to be as an agricultural reforms or an agrarian reforms, which involved in changing laws, regulation and customs regarding with the land ownership is concerned. It said that is land reforms was of the object that it said that is wherever where the land is backed by the property of government or where the redistribution of the government land is required, where in such cases we do go down to the Land Reforms Act, understanding how this redistribution of land can be effected with. So in a way we can say that the Land Reforms Act refers to the transfer of ownership, that is where taking away the land from that of the more powerful person and redistributing it with the persons who are less powerful. So the common characteristics of this land reforms is something it looks in, that is all through the state, I can say. All through the state, if you look, the common feature that what we can see of this land reforms is it aimed at bringing a modification, replacement, arrangement and giving the possession to those persons who are in the use of land. And we also see that nothing less than the revision when the land reforms was brought in. In fact, the land reforms was initiated by the political process and reforming the land policies, serving upon the change in relationship to the persons who are holding the land and to that of the person who are the communities of agricultural areas. So in a way we can say that land reforms is an agricultural reforms which it has started with. And what is the importance that it has been brought in? On what idea or on what footing it was being brought in? See, I was saying you even in my introduction class on the land laws as concerned. For a farmer, a land is more dearer than his wife. For a farmer. So nothing above than the land he looks upon with. Even he never looks upon with that of the land which is other than for the cultivation. He always looks upon the land which is used for agriculture. So the land, and I say agricultural land, is more dearer to any farmer when comparing with the all other things that is being there. But this farmer whom he loves with, whom he has very dearest attachment with, this farmer is somewhere neglected, is not given with the right of enjoying. And though we say on the other footing, if you look upon with, India is predominantly an agricultural country, we all know this. But whether the condition of farmers is good enough in the same way that where we are having a predominancy of carrying out the agriculture, no improvements has been made in this regard to protect the interest, to provide the suitable platform to the farmers to carry out their profession. There are many problems that which we have come across in respect of the agricultural issues, which India is also facing to it. One is, we see the production that is being taken in this country is very, very low. That is average production if you take per each acre that if you look in, it is very low, extremely low I can say, I don't say very low, extremely low comparing with that of the other countries, which has led the farmers to a poorer situation. And we can also say like this is the sector which is largely underperformed with. Why I say this underperformed with is that out of the total agricultural land which we are having, that is arable land, cultivatable land, only 43% of the land is being put into cultivation. And if you look at the GDP, though we call it, we are predominantly an agricultural country. If you look at the GDP, the contribution of agriculture to the GDP of the country, it is only between 13 to 15% of its contribution. And it gives 8.56% of its contribution to the export. But still we see the maximum people are depending on the agriculture with earning an averagely very low rate of income. This is one such reasons, or these reasons has brought a worry among ourselves to bring in a reform to the Land Reforms Act. And even if you look with the industrialization, my friends, it is more than 50% of the industries which are there in the country depends on the agriculture. But still that is not being catered to with. So also 60% people are employed in this sector, and that is one great problem we are seeing upon with. Later on we see that urbanization and migration has been taking place effectively because of the low productivity, low income. As a result of this, my friends, we see unskilled laborers are being cropping up here. All this has led to several problems, and one such important problem is the food security, my friends. And what is the problems that is being faced by the farmers? The productivity is very low. That is, as I was then mentioning to you, with the average growth, if you look in, that is a person growing, it says that is a person who is required to grow, that is the crop which can be grown by one person, there we are employing or deploying 3 to 4 people for the same work. This has led to the very growth productivity. The manpower is being wasted. And my friends, though we predominantly say that we are an agriculturalist country, the major crop growing in this country is wheat, pulses. But it is so unfortunate, even after the green revolution which has been taken place in India, still, my friends, as far as the wheat is concerned, we are placed on the 36th rank. When it comes to the rice, it is 50th rank. When it comes to the pulses, we are under 138th rank we are listed in. So these factors makes little worrisome for us as where we are heading to. Why we are going, the way in which we are going is good enough. What is the reasons behind this? This is one problem. That's why I said the productivity is one such problem. So also we see the problems that are faced by the farmers is instability in the monsoon, that is affects the crop growing pattern which we have, or the crop pattern what we grow is not in terms with the scientific manner, because we very rarely go with the multi-cropped irrigation system. Ownership of land is one such basic concern which is varied extremely from one area to the another area. The condition of laborer is very pathetic. Low quality of seeds is always been supplied, which always the farmers are complaining upon with this. Poor agricultural marketing is also one such greatest effect which we can see in respect of the agricultural issue is concerned. So, taking these all into a consideration, we felt that there shall be a land reforms which has to be brought in, that is agricultural reforms in India. And of course, if you look at the agricultural reforms in India, it has 4 phases. That is first phase, phase 1, phase 2, phase 3, phase 4. That is the development has taken place, the movement has taken place in respect of bringing the reforms in India. That is the first phase is between 1950 to 1965. Green Revolution period we call. That is the second phase, that is it is 1950 to 65, it is a pre-Green Revolution. From 1965 to 1980 we see it is a Green Revolution time. From 1980 to 1991 we call it as a post-Green Revolution period, and from 1991 onwards we call it as an economic reforms period. This is how we see it, but the first 3 phases that what we have passed out almost spoke with the land reforms issue concern, or it was more concerned upon with the land issue. So all this made us to understand the importance of land reforms. Thereafter, my friends, the Land Reforms Act was being brought in for each state. It was asked to be each state. Of course, several systems was brought in. In fact, the first object of this land reforms was or I can say agricultural reforms also, initiated in abolishing of intermediaries, that is zamindari system. It also looked down into the tenancy reforms, abolition of intermediaries. It aimed at providing a ceiling for each individual to hold the land, that is in case of land holding. You would remember this, that the Bhutan movement has taken place, which said that the persons who are holding an excess land shall be voluntarily surrendering those land in which they are holding an excess. And it also spoke upon with the consolidation of land holding and also cooperative form. So in this form, my friends, the land reforms aimed with. And there was also various lands revenue settlement to cope up with this thing we see. That is permanent settlement we have come across, Malwari system we have come across, Rightwari settlement or quinquile settlement, we call it as quinquile settlement, which is called as Rightwari settlement, we call it as, and also quinpoina settlement we call it as. That is fought by Warren Hastings. So there are several laws which has been brought, or several ways it has been made its effort in bringing out the effective land reforming system in India. But friends, when it comes to the Karnataka Land Reforms Act, even the Karnataka Land Reforms Act was brought with an object of providing a land reforms in an area of the Karnataka and also to see that all those arable land shall be cultivated and no land shall be left vacant. That was the idea in which it was brought in. That was the idea. And if you look at with the enactment, that is the Karnataka Land Reforms Act 1961, friends, this act was called as Karnataka Land Reforms Act 1961, which was enacted to the whole state of Karnataka, brought in for the whole state of Karnataka. The first provision of this speaks upon with this, that is enforceability of this enactment, that is section 1. When it comes to section 2 goes with the definition of this lands. Of course, I may not be literally going on certain definitions, but I'll take few definitions of this, very few definitions from the point of your examination. I'll be discussing to you with this. What is an agriculture? Let me not go with the land. What is agriculture? Section 2 capital A class subclass 1 Vyavasayatana ಹೇಳ್ತೀವಿ. What is this? It includes, that is agriculture means any act of irrigating a land or causing an irrigation of the land or plowing the land, all these things. But what the act says, it includes horticulture, raising crops, grass, garden producers, or dairy farming, poultry farming, breeding of livestock, and also if the land is used for grazing purpose. So all this shall be considered to be as an agriculture. And if you to speak with who is an agricultural laborer, section 2 class 2 says with us, agricultural labor is such person who is being principally dependent on the agriculture for his livelihood, or a person who deploys his manual labor on the land, that is including an assistance where is given for the purpose of irrigation or even for the purpose of preparing the implements of agriculture. I repeat this, a person who is engaged himself in the preparation of an agricultural implements is also considered to be as an agricultural laborer. This is one other meaning you have to understand, the definition you have to understand. And the another important definition you are required to clearly go through or understand carefully is the definition of family here, 2 class 12, which could be asked for your short notes also. So when it comes to the definition of family, for me in a general sense, if you say a family can be a joint family or nuclear family, we can put it in any of these sense. But when you go with the definition of family, because many of the circumstances, in many of the cases, we are required to undergo with what a family is. The courts have appreciated on the basis of the definition given to us under the Land Reforms Act. So here, a family means an individual, like it goes on giving a list that who would form to be a family. It gives out the 4 areas there. One is, in case of an individual, then such individual, if he has a spouse, then his spouse, then that spouse and individual, along with the spouse and individual, there can also be a spouses for it, that is spouse or spouses, and a minor son, I'm not speaking with the major son there, a minor son and unmarried daughter, whether she is a minor or major. This would form to be a family on the first part. If you go with the second part of it, it is again a case of an individual, where such individual, and if he has no spouse or spouses, that is spouse in a way I can say, no spouse, then it is such individual, then is minor son and unmarried daughter or daughters, whatever it is. Such could be a family. Or in case where of an individual, if he has already divorced his spouse, then it is again himself, that is the individual, that is that spouse, and if the spouse, the children are not been married, and if he is also not been married, then the minor son of that spouse and also unmarried daughter, whether the child is in custody of him or not. I repeat this, if it is a case of divorced person, that is if the spouse have divorced the other spouse, then, and if they have not remarried, then that individual is minor son and unmarried daughter, whether they are in his custody or not, or where they are in their custody or not. This is a family. And the fourth situation, it says, where if an individual is to be considered, that is both the individual, that is both the spouse, each other, husband and wife here, if both are dead, then the minor child and unmarried daughter forms themselves to a family. So this is the definition what is being given to the family. So within this definition, we would understand what the family is and what the family can hold the property. This is one important definition we should go. The next definition, of course, it is under section 2 class 34, it is tenant, which is very, very, very important from the point of examination, which could be asked for the main question also as well as for the short notes. Any of this part can be asked for the short notes. Who is this tenant? Friends, again when I say tenant, tenant is with reference to that of the agriculturist. It speaks. It is nothing more, because as I already said, land reforms is nothing but an agrarian reform. We are only concerned with the agriculture and nothing more than that. We are only connected with the agriculture when discussing with the land reforms. So a tenant here, it means to say that is an agriculturist, that is where he is cultivating personally and he holds the land under lease. That is what we call it. That is a person who happens to is an agriculture, who is cultivating the land and is holding the land as under the lease from the landlord. Such person is said to be called as a tenant. And this tenant includes, this is what is more concerned, you have to go specifically writing each and every area. That is, person who is deemed to be as a tenant, that is under section 4. Then person who has been a protected tenant, that is who has been protected from the eviction, that is under the Karnataka Tenancy, within the brackets Temporary Protection of Eviction Act 1961. That is a person who has been protected from that of eviction. Or the third one is if a person is said to be a permanent tenant or a person who is a protected tenant. All these four categories, apart of the general definition what it includes with, shall form to be a tenant under this act. So all these people can be considered to be as a tenant. Now, apart of the person who is given on lease for the purpose of cultivation, the other person that what I just mentioned to you is person who is called to be as deemed tenant. Deemed tenant, protected tenant and permanent tenant can be also asked for your short notes. Now, who is this person who is called to be as deemed tenant? See, when I say deemed tenant, it is again says like this. Person who is lawfully cultivating the land which is belonging to that of another person, that is, such person shall be deemed to be called as a tenant of such land, then the persons who are not cultivating personally, where if the such land is not been cultivating personally by the owner, it says, that is, the general understanding, if you go say, yes, the owner should be cultivating the land. If the owner is not been cultivating, and if any other person has been given for the cultivation, of course we have an exception, let me go with that exception also, but still, if the land has been cultivated by any other person, and that person who is lawfully cultivating the property of the other, then such person is said to be called as a tenant, deemed tenant. He may not be under the lease, but still, where a person is cultivating the land, where owner is not cultivating with, then such person is called to be as deemed tenant. But this does not include that a land or a member of the, that is, a member of the owner of the family who is cultivating with, like the family definition here, what we see, that is the spouse himself or the child of them or unmarried daughter, if she is cultivating, then that does not include. That's why we say a member of the owner family is cultivating, that does not include. Or where a servant or hired laborer who is cultivating the land on the basis of wages payable, whether it is in cash or kind, to that of the person, or where the cultivation has been made on the basis of crop sharing, then that is maybe the members of the family or any other person for that matter. That is, if such person, the cultivation is carried under the supervision of the owner himself, then such person are exempted from the definition of deemed tenant, or from the class of deemed tenant. Or in the other way is that the mortgagee who is in possession of the property cannot be considered to be as a tenant there. So except of this, if a person who is holding a land, who is in occupation of the land otherwise than the owner of a land, and it is not a subject of lease, then such person shall be called to be as a deemed tenant, provided in such case, my friends, it is on the application made by this owner within 1 year of time of that the person so appointed, the tribunal shall have a power to declare that the person is a deemed tenant or not. And this decision, what is being passed by the tribunal, can be reversed in case of appeal as to the declaration of the decision of a person is a deemed tenant or not. But however, we shall see that such person can be considered as a deemed tenant. Friends, I would like to go with the two interesting case here, discussing upon with, yes, who is this deemed tenant. A very interesting case. One is in case of Jiva versus Ragavaya Ningappa's case. In fact, here there were three sisters, and in a common way we see, in today's context, if you look upon with, two sisters. Among these three sisters, two sisters was married, probably they were married to urban area, they were settled in urban area, and only the elder sister of this three sisters and this husband was cultivating the land, and they were also cultivating the land of these two sisters also, because it was all these three sisters had got the property by way of inheritance. They were holding the land, and the elder sister of the husband and elder sister was cultivating the land, and two sisters were staying in urban areas. After the land reforms was brought into effect, the member, that is the brother-in-law of the two sisters, claimed upon, that is brother-in-law, of course, brother-in-law claimed for this thing, that is to treat him as a tenant and give a right of those property which he was occupying with. The question came up before the court was that whether the person who was cultivating the land can be considered as a tenant. And there the court, going through this, it said that is looking down to the definition of 2 class 12, that is what a family is. The court going through this, it said that there under the definition of 2 class 12 as to the family, it does not include brother-in-law. It only includes individual spouse or spouses, or minor son or unmarried daughter. Has this brother-in-law was not a member of the family, you cannot say to that the family, that the property was cultivated by the family themselves. And there the court said that yes, this brother-in-law, he is entitled to claim a tenancy, and he can be a member of, he cannot be a member of that family, or not being the member of that family, he can claim a right of tenant over that property. This is one case. And another interesting case was that it's Gopal Rao versus the land tribunal. One Mr. Baliram had owned a vast extent of land in his name. So what he did is that he leased out certain land to his younger, that is elder brother, that is eldest brother of him. Then, that is this eldest brother was cultivating the land. After the act was brought into, the claim of petition was being made by the elder brother, which was rejected on the ground that they were the members of the same family. And of course, if you look upon with this, what it said is, as Baliram were a member of a co-partitionary, that is his major brother, and also himself was the member of the co-partitionary property, then the question of the family and the relationship between these persons, as we exist, we find it that they does not come under the definition of landlord or tenant as it exists. See, I was saying you at the beginning of the definition of family. Generally, we say that it is all the family members. Whether that is my father, mother, that is, and my grandfather, grandmother, if they are alive, or any sons and daughters, if they are, whether they are a aged person or whether they are mature or not, it becomes immaterial. All those, probably if those person, that is sons or daughters, even if they are married and if they are staying with us, all this we consider as a family. But when it comes to the definition here, it says no. Because though in a sense, that's what the court also observed here in this, they were the member of co-partitionary property. As such, there do not exist any relationship as to the landlord and a tenant, because when you look into the personal relationship, we can say that though they are the member of the family, but they cannot be, that is, on the basis of this membership, we can be considered as a landlord and tenant. In a limited sense, if you say the personal relationship which is arising out of the family can be deemed to be as a tenancy, that's what we understand with. That is, when an appeal was being preferred before the High Court on this regard, the High Court made its observation saying that though the elder brother, that is major brother or elder brother, was the member of the family, both were the co-partitionary members, but this elder brother does not constitute to be the member of the family under the definition of 2 class 12. Because what there it said, individual, spouse or spouses, or a minor son. It says minor son. So, if I am an individual, then I am a family, and my spouse or spouses are the family. My sons and daughters are my family, not my elder brother is my family. That's what, taking the definition, it said that in such situation where the elder brother enjoying the property of this Baliram was good enough, and there established a relationship between a landlord and tenant. So, that is, Baliram was a landlord, and the brother who was occupying the land, who was cultivating the land, would form to be a tenant of this Baliram. So this is how we see, my friends, where a tenancy can be established with. So in such cases, we see it is a deemed tenant. Of course, when it comes to section 95, that is by the Amendment Act of 1974, it says that is after the Amendment Act of 1974, there is a restriction on the creation of any tenancy, except where in case of soldier, seaman, they can have a creation of this tenancy, but except of this, no person can have a right of creating a tenant. So this is what we understand with a deemed tenant. The next comes under the same area is the permanent tenant. Friends, when it comes to the permanent tenant, that is 2 class 23 it speaks with. That is, a permanent tenant is a person who is cultivating the land personally in such manner, that is, whose tenancy cannot be proved by that of its antiquity. I don't know from how many years back that the property was being enjoyed by me, my father, my grandfather or my great grandfather, I am not know from what time the property was in cultivation and we were in occupancy, I don't know. But the property is not mine. I am just cultivating the property on behalf of such person or behalf of the owner, and that cultivation is being carried through all my days. That is myself, my father, my grandfather, my great grandfather, I don't know to what day it is. So in such case, it says, where the tenancy cannot be established or proved by its antiquity as to the tenancy which I am holding with, or where my tenancy or whose predecessor in title is entered in the records of right showing that I am the occupant of the land, or where it is under the custom or under the agreement or by the orders of the court. If a person happens to hold a land on lease permanently, then I am said to be called as permanent tenant. I repeat this, that is 3 circumstances we can make. That is where the use of land cannot be proved by its antiquity, or where the predecessors were using the land and the title has been, that is as to the use of the land, has been recorded in the or registered in the records of right, or where a custom or under the agreement or by the orders of the court. If I am using the land as a permanent tenant, then I should be called as a permanent tenant. Or otherwise than this, my friends, because Mulangidars are also considered here, especially in Karnataka, who holds the land as Mulangidars, Miresedar, Katakul, includes any person who is in tenancy under the provisions of the law, that is enactment prescribed in, which is coextensive with the duration of the tenure, then they should also be considered to be as a permanent tenant. So these are the circumstances wherein we can say these are the persons as a permanent tenant. Then comes the protected tenant. See, one thing you should understand is the time. When I say protection, if a person is continuously enjoying for the period of 12 years, then he should be considered to be as a tenant. That's what permanent tenant says, that a tenant of any land, if he is holding the land continuously and it is cultivatable by him personally for a period of more than 12 years of time, that is after his appointed day, then such person is said to be called as a protected tenant. That's how we see tenant can be in the form of deemed tenant, permanent tenant and protected tenant. So protected tenant is where person is cultivating the land continuously, that is from the appointed day. If he is continuously cultivating the land for the period of 12 years, then a person can be called as a protected tenant, which includes, section 2 clause 27 says, which includes, that is any tenant who have come to hold the land by way of inheritance or by way of succession. That is for the past 12 years. Maybe my father was holding the land for 7 years. Now after this, me, that is myself, that is the tenant, is holding land for 5 years, which is 12. So if I am holding continuously the land for 12 years, that is by way of my father, after the death of my father, if I have succeeded and if I am holding the land, though there could be 2 persons here, but if my holding of the land is continuously for the period of 12 years of time, then I should be considered to be as a protected tenant. Or it includes the second one, if the tenant is holding the land for any time for the period of 12 years, which is in a different land. Suppose say if X is the landlord who holds land of at 4 places here, and if I am given a cultivation of the land at 3 years at this, 4 years at this, 3 years at this, then I am cultivating this land from past 2 years of this land, which is belonging to the same tenant, same landlord, which is situated in the same village, not in a different village. Then for the purpose of calculating the permanent tenant, all this could be taken together. All this could be taken together and the person can be considered to be as a protected tenant. This is the second criteria. The third criteria is that where if a land is being held by a person, that is by 2 or more persons jointly as a tenant, and such person, if any one of them has been cultivating or togetherly they might be cultivating, or they might be cultivating on an intervals with certain intervals, then still they are considered to be as a protected tenant, and they also fall under the category of deemed tenant. Suppose if 1 and 2 are cultivating jointly, maybe because of sickness of one, only 2 is cultivating, then there is a continuation. And for the purpose of cultivation, if only 2 is cultivating, 1 is also deemed to be called as a tenant for that purpose, and it should be protected under the enactment. Though is not actually cultivating, but by continuous cultivation of either one of these 2 can also form to be a protected tenant. And the fourth one is this: if the tenant has sublet the land on account of his temporary disability, or because of any other reason, because of his other reasons like infirmity or whatever it is, if he has sublet the property to any other person, then the person who has acquired the right is to be protected tenant, and if he continues to position to hold the property personally for the period of this sublease, so such person can also be considered to be as a tenant here. So in this way, my friends, we shall see that the tenancy can be made. However, my friends, when we are understanding with the tenancy, we say that is all this issue has come up. That is more particularly when I speak to you with the tenants, that's what section 6 goes with. Says that the more of this provision has come up to encourage the self-forming, and says that no tenancy of any land shall be terminated on the ground that there is a fixation of duration. Say that I have given you a tenant for 1 year, and for 1 year you are not no more. It is not that. No, nothing will put an end to that of the duration unless it is been taken back by the owner. That's what it says. That is, restoration of possession of tenant is dispensed under certain circumstances. We say section 7 speaks upon with this, where it says that where if the predecessor in title, if they are holding the property, that is a land on or before the 10th September 1957, 10th September 1957, his predecessors are holding the land in the property, and if they are continue to hold the land, and even if it has been taken back by the owner of the property, and if they have cultivated for the period of 15 months, then they can move before the tribunal to consider themselves as a tenant and restore back the tenants. So this is how we see what a tenant is. The next comes is, the definition is improvement to class 15. Friends, when it comes to improvement, quickly I'll go. It is again with reference to the land, that is agricultural land, which says that any act which is being done by you, which adds to the productivity of that growing, then we can call it as an improvement. Or I can also put it in this way: if any work that is being undertaken by you, which increases the production of the agricultural growth on that of the land, then we can consider that to be has an improvement made by you. That is, where the occupant or where the tenant or where the owner of the land, for the purpose of improving the land, for the purpose of high yielding, do any such act directly which would be beneficial for the purpose of agriculture, and as provided under the provisions of the act, if it does any such act, then we can call that to be as an improvement, which includes something like this: construction of tanks, wells, water beds, water channels, embankments, or other storage facilities, or supply and distribution of water for the agricultural purpose. If you do any such act for this purpose, it is an improvement. Or if for the purpose of this, if you have any construction of work for drainage of land, for the protection of land, for the flood erosion, or if anything that could be caused a damage from that of the water or floods of water, any work that you do, it is an improvement. Or you can have a planting of trees or plantation crops for reclaiming or clearing or enclosing or leveling the land has concern. That is also an improvement. The creation of any building or within the vicinity of the building elsewhere in the municipal urban areas, that is municipal and urban areas, reasonably required for the convenient and profitable sources of occupation of the land, that is also called as an improvement. Or if there is a renewal or reconstruction of any foregoing works, that is making an alteration in addition to this, they are also considered to be as a improvement made to that of your land. So in all this manner, we shall see that the improvement can be effected by you. So this is the definition which you can go upon with this. And of course, my friends, I want to take another important thing here. Apart from the prohibition of lease and restoration of a tenant, of dispossessed tenant, whatever it is, under the circumstances, we say, I was speaking to you under section 7, that is when the tenant can be restored back under circumstances, that is two circumstances, is one where his predecessor's name is entered in, or where the tribunal after inquiry has reasonably found fit that the disposition was taken place with respect to the tenant. On the basis of its order, they can be restored back to that of the tenant that is there, that is as of 10th September 1927, they can establish it. That is one. But another important thing that what I want to discuss you here is with section 8, rent. Because the rent, it says again subject to the provisions of this act or anything withstanding to that of the act, that is when I say anything withstanding to, if there is any local custom or usage, or where if there is any agreement entered between the parties, or if by the orders or decree of the court, if they are bound to pay certain amount of rent, then that would be the rent. But otherwise than this, if I am to say rent means any rent payable by the tenant to the landlord has annually, which he has agreed to pay or is paying annually on that of the land which is using without any agreement. But if some amount of consideration has agreed, maybe sometimes it could be by way of crop sharing, or it could be by way of some amount that whatever that he is agreed, depending upon the percentage of the amount that what is going by way of cultivation. In such form, if any rent is being paid by him annually to that of the landlord, then that is called as rent. Or it also includes sometimes if that is not being made, then such rent shall be in aggregate payable to the 10 times of the land revenue what you are paying with. That is 10 times, if not the land revenue, then the 10 times of the water rate what you are paying upon that of the land can be considered to be as a rent. And that's how we see there are various classes of lands that is being provided under the Land Reforms Act, not with the classification what I spoke to you at that of the land revenue. The classification under the Land Reforms Act is concerned. The classification goes in A class land, B class land, C class land and D class land. When it comes to the rent payable on that of the A class land, then the rent payable for the A class land is 16 rupees 50 paisa per acre what you are using with. That is where, when I say A class land, in a simple understanding, where the crop where the land is capable of growing 2 yieldings per year. That is what we call it as A class land. And if that is the land what you are using in, then it is 16 rupees 50 paisa per acre you have to pay. Then it is 10 times of this, or 10 times of the water rate of this will be the rent. If it is a B class land, then 11 rupees per acre. If it is a C class land, it is 5 rupees per acre. And if it is a D class land, that is what we call it as dry land, it is 2 rupees or 250 paisa or something. It is for the acre of land. So where the rent is not fixed between the parties, then whatever that is amount has been fixed, it is in this way they can calculate and that shall be made liable. But where any excess amount specified therein and it made in or paid in that, the tenant is not liable to pay more than that of this rent what it has been fixed here. But if they have agreed, it should be in terms of agreement or has a customary practice. If it is there, they have to undergo with this practice and do. But nothing has been made out, then this could be a rent what is being payable. Otherwise than this, the Tahsildar of the concerned jurisdictional area shall also have a right to determine any dispute with respect to the rent payable to the person as per section 9 class 2. So if any dispute arises as to the payment of rent or with the rate of rent what is payable, then the Tahsildar shall have a power to go determine upon the amount of rent. And even under section 9, my friends, we come across with the deemed rent. Deemed rent is something, my friends, where if the landlord evades to receive the rent, or if he is not giving a receipt on that of the to the tenant of which the rent is payable upon him, and the tenant is said to have deemed to have paid. I can say the tenant is said to have paid or deemed to have been paid the rent, wherein if this rent is being paid by way of postal money order, or if the same is being deposited with the Tahsildar. In such cases, we shall see that the amount is said to have been paid, and the rent what is being paid is said to be called as deemed rent. And if a dispute is between the landlord and tenant with regard to this also, as to the payable of rent, an application can be made by the landlord as to that of the tenant, and again it would be determined by that of the Tahsildar. So in this way, my friends, we can say, and of course in this regard, section 10 speaks with the rights and liabilities of the landlord. As what would be the rights? That is, you can seek that the landlord is not liable to make any such contribution towards that of the cultivation of the land when it is being given on cultivation, and the landlord shall also, or any person on behalf of him in this behalf, can also have a right to recover the rent what is entitled to be received by him. So in this manner we can see this, that the person shall have a right. That's what section 10 speaks about. 10 capital A says that liability to pay the land revenue. That is, after the Amendment Act of 1974, we see that the tenant is liable to pay the land revenue, water rate, cess, fees, levy on all this when is during the period of lease. So he has to pay all those things as that is required under the Land Revenue Act or under the land reform. So in this manner, my friends, we shall say the rent is to be understood, and the rights of the tenant and rights of the landlord can also be understood.